very serious matters. Because we run to court, everybody looks at court as a temple of justice. And so, my Lord, we were compelled to file a complaint against you with the Uganda Judicial Service Commission. And if you have not received a notification of that complaint by the Judicial Service Commission, as they are required to extend it to you, I'm sure you will receive it. And so these two issues tie up. In this case in which we are charged to be in another court, we end up still in your court. In fact, today, my Lord, apart from the intended commencement of a trial, you have set aside today to hear our second bail application today. This was the application we made in April of this year. But my Lord, in your ruling regarding the mandatory bail, you categorically stated that it is my considered view that priority be given to hearing the main case other than bail applications. In other words, you already have a view about bail applications, that they are useless. What is important is to hear the case. Have expressed that view in writing under the court seal. So that you also hear another bail application. Maybe that's why our case also ended up here instead of the court where it was supposed to be, so that you are sure now that the trial has begun and applications for bail are redundant. So in summary, my Lord, one, we seek to understand why we are not in the International Crimes Division, to where we were indicted. And two, whether and two, my Lord, whether in light of what just said about my complaint, our complaint, my complaint and the complaint of my colleague Haj Obeid Rutale, against you, which complaint in fact seeks one of the things that it could achieve would be to remove you from the office of judge. Whether in those circumstances you consider that it is still prudent that you continue with the processes of establishing justice for us. That's all, my Lord, that constitutes my that's what constitutes the concerns that my colleague here, Haj Obeid, and myself wanted to present to you. And as I have said, they are matters of very, very grave concern. We've been in jail for nearly a year now. We are not young people that can be easily adjustable. We have lost so much at a personal level that we would be doing. My Lord, I'm grateful that you have allowed us finally to present these concerns to you and to this court. In case the Judicial Service Commission has not extended our complaint to you, I have a copy here which we can gladly avail you, my Lord.
Direction state is taking. They attempt to smuggle in an application to amend the indictment. My Lord, the arrest
must not only be done, but it must be seen to be done. The simple question here is, in view of our client's indictment upon the court to the Judicial Service Commission, if you continue handling the matter, will the reasonable man will the perception of the reasonable man be that justice can be done in your court to the accused persons? My Lord, even with the seat of authority, judges do remain human. And are affected by issues that affect other human beings. So my submission is that on that alone, the court ought to recuse itself. But that is not all. On the issue of denial of mandatory bail from the eyes of A1 and his colleague A2, and it's called mandatory bail for a reason, because upon a set of circumstances being fulfilled, the court has no alternative but to grant bail. And those set of circumstances is accused persons having spent 180 days in custody, which A1 is reminding the court how it dealt with the matter, by stating that it had no record of the court-martial, the general court-martial proceedings. So even on that, those issues tabulated without going through what the A1 directed the court, will the perception be that these three gentlemen can get fairness before this court? The perception is important, because unless if subjects have confidence in courts of law, then law and order become under threat. The other very important issue raised is about the order from the Nakawa court to the High Court. Because it's an order. The order was to the International Crimes Division. A division separate from the division in which my Lord serves and in which we are today. This is the High Court Criminal Division. The order was the file be sent to the International Crimes Division. The lingering question, how did the file find its way here? Those divisions are administrative, set up by His Lordship, the Chief Justice. Was there perhaps an order by the Chief Justice transferring it from one division to another? Or are the divisions of the High Court allowed to take away files belonging to another? And if that is the case, what is the impression that would arise in the minds of reasonable people? How did it land here and why? Is the question. My learned junior, Mr. Biribumbuka, says that we are perpetual complainers. I will say we are very consistent on issues of fact, on issues of law, and rules of procedure. On that, we are consistent. And if he finds fault with that, then it is unfortunate. We do insist on our rights where the law is clear, whether it's mandatory bail or an order committing the proceedings to a different division of the High Court. My Lord, the whole scenario to us signifies a pattern of erosion of the right to fair trial, and that is what I got from our client's long address to the court, that he feels the right to fair trial, even on elementary matters such as mandatory bail, has been eroded by whatever is happening, beginning with the illegal rendition from Kenya. So what I hear him saying is that this whole case is founded on illegalities, one illegality upon another. A court of justice should not have to act or give any color of right to illegalities. A court of justice should slam the door shut on illegalities for justice to be done. Finally, from me, not from our side, the courts failing to release them even when the warrants of the court-martial expired. That is after the Kabasi Guruka ruling of 31st of January this year. Those warrants expired on the 3rd of February. Yet they were not released. They continued in custody. And the process continued going on without the courts acting on the illegality. That does make our clients aggrieved, and they feel that this case is a build-up of illegal actions. Not to mention the issue of territorial jurisdiction. The Constitution of Uganda is very clear. Courts of Uganda have jurisdiction within Uganda. The acts alleged were abroad. So even that itself becomes an illegality. Arrest without, it's 126, arrest without warrant in a foreign country, without due process. So those are the illegalities I heard our client going on about. So I would like, I just want to end by referring the court to Article 129. It begins at 126, but the most instructive is 129. Judicial power of Uganda. 129. Courts of judicature. This is a court of judicature. Judicial power of Uganda shall be exercised by the courts of judicature, which shall consist. So what I want is just the word of Uganda, not of Kenya, not of any other country, just to indicate the territorial limits of your jurisdiction. So that when A1 says it is one illegality upon another, the court is able to grasp. I cede ground to my colleagues. I know that Lukwago and Kalibara